We have three wonderful panelists who are here to bring us a variety of perspectives. We're going to start with, to my right, Danya Perry, who's the founding partner of Perry Law. While she enjoys a breadth of experience and has received high praise for her work, her role as a former Southern District of New York prosecutor and New York State Deputy Attorney General makes her thinking on all of these issues particularly important. You'll hear about some pretty famous cases she's worked on. We, of course, have Attorney General Matt Platkin sitting next to her. As we will discuss, state attorneys general can take a lead role in attempting to combat the autocracy, and we look forward to the thoughts of New Jersey Attorney General Matt Platkin. He also serves on the executive committee of the National Association of Attorneys General. And, of course, we have Judge Nancy Gertner. She's a well-recognized legal scholar, bringing her perspective as a former United States District Judge for the District of Massachusetts. She's currently a senior lecturer on law at Harvard Law School. And we are here to talk about the best defense being a good offense, right? A good offense. We're here to talk about the offense. As Norm says, the short term, what are we going to do today? What are we going to do tomorrow? Medium term and long term. One of the things we've heard from several panelists today is that we can talk about Project 2025 and the threat, and 2025 sounds like it's a long way off. But when we talk about the reality, we've heard from our panelists today, we know that we are living with some of the realities of Project 2025 right now, right, in July of 2024. And so I want to start off by hearing from our speakers who have all had their experience going on the offense. Danya, why don't we start with you? If you can tell us about some of your experience, some of the tools you've used, and some of the lessons you've learned.
Sure. Well, thank you so much, Allegra, and thank you, Norm, and thank you, all of you, for sticking it out. As Dahlia Lithwick said a couple hours ago, she was gobsmacked then that you guys are still kicking around, and now, even after cocktails, that you're all toughing it out. So that portends well for the next couple of years. So I come from this. We've heard different perspectives from so many brilliant panelists today who have all kinds of prescriptions for how to get through a potential autocracy should Trump be reelected. You know, there's organizing, of course, there's voting as the ultimate bulwark. You know, all kinds of things, but I'm a trial lawyer, I'm a litigator, and so that's the perspective through which I view this. And Norm asked the question, you know, what can we all do? So I'll just, if you all will bear with me, tell you what I've done and what I plan to do going forward, and in partnership with some of the amazing organizations who have helped put together this conference today and who have been represented on these various panels. So as Allegra said, I started my public service career as a prosecutor in the Southern District of New York, ended up as chief trial counsel and then deputy chief of the criminal division there, and then went to state prosecutions for a while, where I was the chief investigator on an anti-corruption panel. And that you know, has kind of shaped my thinking a little bit about some of the matters that we'll be talking about. And then I kind of fell backwards into resistance litigation, I guess we can call it. After I started my little litigation boutique several years ago, my very first client was Michael Avenatti, kind of a blast from the past. Right. And he stood accused of, in the case I represented, it was the first of several prosecutions, but this one was for alleged extortion of a giant company, Nike. And the part that really threw me, because I've been in and around you know, high-level federal prosecutions for most of my career, what threw me was that he was, as a first-time white-collar offender, was remanded and thrown into solitary confinement. And I said, that is crazy, what's happening here? And I'm not a very, you know, overly political person. I'm the farthest thing from a conspiracy theorist, but it was bananas. And eventually, through litigating, you know, Allegra said best offense is good defense. I kind of went on offense there and litigated the case, lost the criminal prosecution for a bunch of reasons, including that. The prosecutors were able to bring in what's known as prior bad acts, and there were quite a few. But I did manage to get him out of solitary confinement. But he was in El Chapo's cell, which in the notorious 10 South unit at the notorious MCC. And there was something that really set my alarm bells ringing on that. And then almost immediately after that, another case landed in my lap, and that's Michael Cohen, who had a little cameo earlier today. I'm sorry he's not here. That case just, it was a referral, and in part because of that weird Avenatti-Cohen connection, that came to me. And that's another man, another lawyer named Michael, who was thrown into solitary confinement. In this case, because he had already been released from federal prison for crimes that you're all familiar with, no doubt, in this room. And he had gotten out, and on parole, they tried to get him to agree to conditions of release that included a complete gag order, essentially, that he would agree not to, do any media, to completely restrict his freedom of speech, including publishing a book that was about to come out right before the 2020 election about his experiences working for Donald Trump. And so he pushed back on that, and he was shackled, handcuffed, thrown into solitary confinement until we were able to use the courts to get him out. So we filed for a temporary restraining order and a habeas petition, which was successful, thank goodness, in front of Judge Hellerstein in the Southern District of New York, and got him out in very short order. So on that, we were on offense. Since then, Michael and I have used that experience and that unconstitutional act in violation of his First Amendment rights to bring an action against Trump, Barr, the Bureau of Prisons, and in what's known as a Bivens action, which is essentially an action to get damages when the government has acted in an unconstitutional way. That is, there is an impossible standard there, as all the lawyers on this panel know and the lawyers in the room, nearly impossible. But we thought it was important to bring because we felt it was important to bring awareness to this case. And still to this day, I think a lot of people don't know the horrific conditions that he was under. He refers to himself as a political prisoner, and I think that is not far from the truth. It is not coincidence in my mind that both he and Avenatti were uniquely, and I really mean this, I've been now around the Southern District of New York in particular, but the federal penal system now for more than 25 years, is unheard of. And so there is something there. Since then, I've been involved in a number of other actions, including when Michael Cohen testified in front of the grand jury in the Manhattan District Attorney's criminal case that I'm sure we'll talk about, because I represented him in that too. Trump retaliated almost immediately by filing a $500 million lawsuit against Michael in federal district court. And so there we were on defense. Cohen was the defendant, but we went on offense there too. And we filed just scores of discovery motions and other motions. We got documents that he didn't want to give us. I was supposed to take Trump's deposition one business day before that was supposed to happen. He voluntarily dismissed the case. So there have been, and then as I mentioned, I represented him in the criminal case where, with my colleague Josh Kolb, who's in the front row, who also helped organize this conference in part today, we prepped the bejesus out of him, hundreds of hours of prep and mock cross-examination and just doing the work and going through the documents, and he withstood withering cross-examination. He was on the stand for a week, and the jury, of course, believed him. They came back in very, very short order with a unanimous verdict on all counts, and that's just, the results. I firmly believe, not, obviously there were many other factors and many other witnesses, but we went through. There was not a single document that we hadn't gone through and prepped him on. And on there, we've heard today about, the plan, the Project 2025 plan, and also what we saw in the last administration. And we heard from Sarah Matthews and Olivia Troy and others who saw firsthand what Trump and his acolytes will do when you stand up to them, when you're brave enough like those women. I couldn't believe it. Sarah was 25 when she stood up. Michael stood up, and he has paid a horrible price. He and his children get doxxed, he was swatted, death threats, and all that. So on there, we tried to go on offense as well. We brought a couple criminal referrals to the various relevant law enforcement agencies, and we also brought or threatened a defamation action against the network OAN, where they said some horrible and defamatory and untrue things about them, and they retracted and actually apologized. So as you say, offense is best defense, and the other way around, you can, look, we've some of the groups who've organized this conference, the ACLU, and really the attorneys general are the bulwarks here, and they do unbelievably important work. They did it the last go around. They brought, as we heard, hundreds of cases, 80% of which were successful. And you'll hear from AG Platkin about the incredible planning that's going in for the next time around. But those are big actions, right? We heard about some of them, actions against the Muslim ban, DACA, the census that required, that had a citizenship question, all those things, very big, impactful, broad cases. To go back to Norm's question, what I'm doing is trying to do the individual defense work, also offense work. We read in the Project 2025 manifesto, Chapter 17 on the DOJ is chilling. It truly got me, and I hate to say it, but in a panic. They have said, and Norm and other people here, Just Security, the threat tracker, Trump has said this. He's, Project 2025, we were just talking about amongst this panel, they're saying the quiet part out loud. Trump has always said the quiet part out loud, and he's very, very openly said he's going after very specific people. It includes Michael Cohen, it includes Biden and his family, it includes groups of people, but there will be criminal prosecutions of individuals. And I have seen in my work as a prosecutor, and I'm sure these guys know as well, when you're going to trial and you have a defendant and have the temerity to go to trial in the federal criminal system, it's almost unheard of, because the cards, I'm now a defense lawyer, the cards are really stacked. You go to trial, and as a prosecutor, you start investigating that person, and you look under every rock for what I alluded to before. In the federal system, it's called 404B evidence, but it's prior bad acts. So you just do you boil the ocean, and you look at anything that person might have done. Almost certainly, you're going to find something. And here, Trump, who's going to have full immunity now, thanks to the Supreme Court, is going, and particularly with the Department of Justice, right? That was just in the ruling. They ruled on that specifically. And he is going to have free reign to say, look at Michael Cohen's tax records, look at, Norm Eisen's mortgage payments. I don't know Norm, I apologize. And, a lot of times you're going to find something just to bring, right, which itself is ruinous in every single way, reputationally, financially. They tried to do that in the last administration. They brought in a special prosecutor, John Durham, right, who did actually bring, prosecuting the prosecutors. He looked at some of the people who were behind what they call the, Russia hoax. He brought 2 prosecutions, and I mentioned before, in the federal criminal justice system, it's unheard of, essentially, to get acquittals. He got 2 because they were just bogus lame cases. But they still were devastating to those human beings who were the targets of that prosecution, those investigations. And so we know it's in the pages, and it's in any number of Truth Social posts from Trump. That's what they're going to do. And so what I personally plan to do is to keep doing what I'm doing. We devote a tremendous amount of our practice to individual defense work. We're going to keep doing that. And, the kind of, we work with many of these groups all the time, and we put out reports, white papers, Brookings Institution, Just Security, and, trying to raise that awareness. And as I mentioned with the Bivens action, the so-called Bivens action against Trump that we brought on behalf of Michael, that was going to be a loser. This Supreme Court, never in a million years, it's on petition right now, never in a million years will they grant cert on this case. But the idea was to try and raise awareness and get the word out there. And so I think the amazing results of this kind of conference and this level of awareness and group building is that, we can all work with each other, and the unbelievable tools, the unbelievable people in this room, especially the press. Obviously, we heard from Jen Rubin and Danya Lithwick and others, maybe in the past there have been some lapses in the way the press has dealt with these issues, but hopefully going forward there's some, consensus that they need to do better. We all need to do better and work together. So Norm did ask us to end on a note of hope. I actually have hope. We've had success, in the small individual litigations that I've been lucky enough to be part of, but Judge Gertner will talk about the federal judiciary's place in all this. I do have some hope, both in the people who will be, on the resistance side, if, this should come to pass. But I do think, and I don't want to steal your thunder, Judge, not that I ever could.
Don't worry about it.
But I do believe in our judicial system still. The Supreme Court, not so much right now. There's obviously a MAGA supermajority.
We're going to get to it.
But the lower courts have really held up. Trump has appointed, I think, 230-something, yes. But many of them were Trump appointees who actually found against him, his policies, some of the criminal cases, the January 6th cases, and they're much less politicized, I think. And so I do maintain some hope there, and of course in the jury system. As I mentioned, the two John Durham cases fell flat. The Trump criminal case went exactly as it should. And so while, yes, the prosecutors, if DOJ becomes completely politicized, obviously there's some concern in terms of the kinds of cases that get to a jury. And if judges become overly politicized, like we've seen with Kazmierek and Cannon, which I know we'll talk about, obviously the evidence that gets in front of the jury also can be shaped. And so those are, of course, worrisome. But at the end of the day, you get in front of 12 ordinary people, peers, they tend to do the right thing in my experience. So I do have some hope. And hopefully when we hear from you guys will have some ideas as well that will give further hope.
Thank you. Attorney General Platkin. Attorney General Platkin, it's very exciting for me to meet you. It was exciting for us to hear earlier from Attorney General Keith Ellison. I come from Georgia. I don't have a lot of experience with attorneys general who go out and protect people's civil rights, so it was super exciting to me to meet you today. You personally have been involved very much in the offense. Can you share with us some of your experiences and some of the strategies that you found to be successful?
Sure. Well, first of all, thank you to the organizers and to Norm and to everybody who's here for this. It's hard to say amazing conference about autocracy, but I'm the youngest attorney general in the country, so that might mean you shouldn't listen to anything I say. But when I was in law school, this would have been unfathomable, that we'd be coming together to talk about autocracy in America. But so my hopeful message is I'm glad that we're calling it out for what it is. I'm glad that we are talking about it, that we're being honest about the risks, because the threats are real. And this isn't a joke. And, what the organizations that are part of today and what you all have done, not just over the past several months, but over the past decade, the impact that you've had in preventing bad things from happening can't be overstated. I mean, and it's both in the substance of what we've done, but it's also in lifting up and showing that this country doesn't stand for what some people want to say it stands for. And that's important. When you look at the history of autocracies around the world, you don't need mass complicity, or you don't need mass participation. You need mass complicity. And so you need people to not care. That's when autocrats take control. That's the history of autocracy throughout this globe. And the fact that so many people have stood up, I was at Newark Airport after the Muslim ban was announced. I was outside the Elizabeth Detention Center, the Immigration Detention Center. I went to the women's marches. And, we need to do a lot more coordination, which is part of what today's about, but don't underestimate the lessons that we've already learned about litigating, strategizing, organizing, and pushing back, because it matters. Danya talked about this, the number of cases that we won from 2017 through 2021. A whole host of bad things did not occur in this country because of litigators in offices like mine and in organizations like the ones that are represented here because of the work that they did. And we're ready to do that again. I want to be clear. We're actually more ready today than we were at this time in 2016. And we're going to be a hell of a lot more ready come November and come January. And General Ellison, who you heard from before, and the colleagues that I have, I've never been prouder to be a part of a group of people who, by the way, and I'm sort of the least known of any of them, are doing this at great personal risk. And it's not just the folks, as Danya talked about, at the highest levels of our office. We are talking about risks to people at every level of government. And so one of the things, when I talk about good offense, that we need to be clear is, A, states and local jurisdictions matter. They matter more than they've ever mattered in probably the history of this country, and states are going to play a leading role in protecting democracy in this country. And it's going to be the case regardless of what happens in November. Because Project 2025 is a 922-page document that is not going to disappear if one outcome in November occurs. And that's not just me speculating. That's what I've seen in New Jersey over the past 6.5 years. And that's what we see in states across this country. The things that are in Project 2025 are already happening in places across the country. We are already, I see Keith nodding, we are already fighting against them. I sued 4 school districts in New Jersey for forced outing policies in New Jersey of trans kids, in violation of a policy that Governor Chris Christie put into effect. So we're not talking about far left stuff here. In Project 2025, one of the things they talk about is impounding all K-12 education spending to schools in states that did what we do in New Jersey, shutting down the entire funding streams for our K-12 education systems. Labor's here. They're talking about eliminating the NLRB, talking about all of the things we've seen post-Dobbs, a national abortion ban. And so these ideas are not going to go away. So what do we do about it? Look, we coordinate, we plan, we don't ignore the threat. And when I say we coordinate, it means we have to be coordinated across states and across our partners. State AGs are going to be incredibly important, as our governors, as our secretaries of state, as our other state and local actors. But one lesson that I think we have to learn from the previous administration is that circumstances have changed. Courts have changed. The law has changed. And while I too have faith in our courts, it would be hard for me to do my job if I had no faith in our courts, I think we also need to be realistic about the nature of the courts and how they've changed over the past 7 years, and where we might bring cases, and who might be the right plaintiffs, and the nature of the cases that we bring if we want to be effective. And then we need to think about how do we go on offense, both in terms of organizing, but also in terms of states like New Jersey, like Minnesota, where, like New York, where we're sitting, where we can do things that provide protection. And we don't even have to look to the last administration for this. Just look at what's happened in the now, hard to believe it's been 2 years, in the 2 years since the Dobbs decision came down. Well, now in this country, we live in two Americas when it comes to reproductive health care, when it comes to health care, period, frankly. And I'm sorry to say that, but a number of us were just in Austin, Texas, at the last remaining reproductive health care center that exists in Austin. And it's a very different dynamic if you live in South Texas than if you live in New Jersey. And that's because in New Jersey, we've enshrined into law, statutory law, state statute, that you have a right to reproductive health care. We've enacted shield laws, which we need to keep doing. We've protected our providers. We've made it clear that they won't be subject to discipline. We've said we won't cooperate with out-of-state investigations into our providers or into people who take advantage of what's lawful in New Jersey. Now, this isn't a typical place for a progressive attorney general to be. Federalism is not usually like the first tool in our toolkit. But now it's where we go, and that's what states will need to do. We will need to continue to pass laws that provide protections to people in our states. We need to do a little bit about what they do. You know, they pick test cases. They're not picking out of thin air when they decide to litigate a case or when they decide to pass a law. Take some of the things we're seeing now on religious liberty, certainly on the Dobbs case itself. That law that was passed was knowingly in violation of settled Supreme Court precedent, but they did it to tee up a challenge. And so we need to be just as strategic in how we push back. We need to be just as coordinated, and we need to be just as thoughtful. And that's why organization, I've seen more organization over the past year than I probably saw in the decade before, because people are taking the threat seriously. I'm sitting on a stage in front of a banner that calls it what it is. These are not normal times. And regardless of the outcome of an election, we are going to be on the front lines. And I say we. Yes, it's state attorneys general, but it's private litigants, it's our judiciary, it's our activists, it's our organizers, it's labor. It's every single resident who wants to say that that's not the America that they want. It's not the America I want for my 5-year-old son and 1-year-old daughter. And it certainly motivates the hell out of me to go to work every day. And I couldn't be prouder to work in a department where people have raised their hands, overwhelming numbers of people have raised their hands, career public servants, and said, I want to help, that I want to be part of this effort. So one plug is if you're an attorney, you're looking for someplace to go, we're hiring. I'm sure Keith is too. And the last thing I'll say is this, because I really do want to let everybody speak and hear your questions. We need to stand up for strong institutions wherever they are. It's not just the federal government that we need to be worried about. We need to protect institutions at every level of government. And you can clap for that. I want to have like a Jeb Bush moment here. And we can't just care about threats to our democracy or corruption some of the time. We can't just care about it when it's involving people that are on the opposite side of issues as us. Unfortunately, we need to bat 1,000 on this issue. We need to be consistent, and we need to stand up for strong institutions no matter who we're talking about, because you can whittle away at norms very quickly, and we've seen a lot of them get whittled away substantially over the last 7 years. And unless we are consistently standing up and showing why independent institutions, strong attorneys general, strong independent secretaries of state, election administrators, why they matter and that they have support from the public, then I don't care what we talk about. If the institutions cannot do their job, we are in a deep, deep crisis in this country. And so that's something that I take very seriously as the chief law enforcement officer in New Jersey. And it's something that I think we should all understand how critical that is, that we have people and institutions in states and local governments across this country that will stand up when the federal government tries to do things like is written in the 922-page Project 2025 document.
Thank you, General Platkin. Judge Gertner, I am so interested to hear what you're going to say.
So am I.
You know, we've heard our first two speakers talk about the difference in the courts. I myself have been litigating voting rights cases, and what I say about once a month is, boy, it must have been really fun to litigate these when the courts were on your side. I can't imagine, but it must have been really fun back then. You're now dealing with young law students, right, who are coming in and swearing to uphold a constitution that is constantly under attack. What are you telling them about Chevron and Dobbs and the Constitution and autocracy? Give us all the wisdom in a few minutes, please.
Right. Well, I'm not teaching constitutional law for that very reason. I don't have an answer, a good answer, because it's not just what the Supreme Court has done to overthrow precedent at a pace that no one expected. It's one thing, you know, I wrote a book about Ruth Bader Ginsburg, and she was actually an incrementalist. She would put things in footnotes that she knew that she couldn't carry the majority, so she would put in interesting footnotes, assuming that time would prove that the veracity of what she was saying. This is not an incrementalist court. This is a court that is in haste to undo the precedent of 40 or 50 years. But let me just sort of start a little bit at the beginning. Wasn't just a judge. I love it when people introduce me as if my life began in 1994. This is not true. I was a civil rights and a criminal defense lawyer before I went on the bench, and I was an unusual pick in 1994, and that's part of, I think, you're getting to what you were just saying. I was an unusual pick. Most judges from 1994 until under President Biden, actually, and to some degree Trump, most judges were prosecutors and big firm lawyers. And they could be wonderful judges, and there were wonderful judges from that mix. But it often meant that, particularly before Biden, judges were selected in direct proportion to their never having said anything out loud. That's how you got through. If you said anything out loud, you would not be selected. And so we have a bench. I've written about this. This is before Trump. The dominant pressure that I felt as a judge was to duck and to evade and to dismiss civil rights. That was the pressure that I felt, to dismiss find waiver, find statute of limitations. The dominant pressure was, as I gave a speech once, to duck, avoid, and evade. Now, Biden has put on the bench people to some degree more like the background that I had, which was a criminal defense lawyer and a civil rights lawyer. And Trump certainly has not the background that I had, but he has picked a very different kind of judge, and I want to talk about that. So the overwhelming majority of the bench is still as it was before Biden, still former prosecutors, big firm lawyers, not necessarily people who had any sense about civil rights before they got on the bench. Trump obviously put on the bench, with the help of the Federalist Society, let me change that, with the direction of the Federalist Society, he put on the bench very, very different judges, and that effort to some degree has been repaid. Eileen Cannon, need I say more? Biden has put on the bench public defenders, labor lawyers, looking at diversity not just in terms of race and gender, but looking at diversity of background. And that makes an enormous difference, because it means that judges should start at different places because we have different experiences, even if what we're doing is sort of measured by being judges, by essentially what the rule of law requires. So there have been changes. I would predict that there will be less duck, avoid, and evade in this bench, particularly given the example of the Trump judges, but that has been a problem, and that's why your experience of voting rights in the courts long before the Supreme Court began to undo voting rights was not great. In addition, I have a good friend of mine who's on the court that I just left in the District of Massachusetts, and she said to me, well, there's interesting stuff going on with the Supreme Court. It's really terrible, but it doesn't affect the day-to-day of the federal courts. And that's not true. That's not true. One of the things that this Supreme Court, I'm going to get to good stuff. Don't worry about it, Norm. I'm going to get hopeful soon. I'm just building up to it. It's the old trial lawyer, just building up to it. One of the problems with the Supreme Court, one of the many problems with the Supreme Court, is that it has lifted the ceiling on law. Everything is up for grabs. And so you could wind up with a Matthew Kaczmarek redoing the FDA, or you could deal with Eileen Cannon, who is suddenly going to re-examine the special counsel's provision, even though the precedent is overwhelmingly in the other direction. So for a constituency of district court judges, there is no ceiling. I felt a ceiling. There were many things I did on the bench that I thought were wrong, and that I'm actually writing about now. It's great fun. But I knew there was a ceiling. I knew there was precedent. I knew there were courts above me. I knew there was a Supreme Court. There is no ceiling now, and that is a problem. So you wind up with a judge like Eileen Cannon, whose first draft of her special counsel decision was obviously written by Clarence Thomas. So I think the courts are complicated. There are conservative courts who will see the Supreme Court as, and will be auditioning for the Supreme Court, as we've seen. The judges who were appointed before, the Biden judges, need to be able to look at the world very differently than they have before, and not just duck, avoid, and evade. Let me just do one sort of side route here. It's not so much Hitler that I think about with the courts. I think about Orban. What Orban did when he came into power was they passed a new constitution. Well, we don't have to pass a new constitution. The Supreme Court has essentially expanded ours. In addition, there was a ruling that because it was a new constitution, you couldn't use precedent from before Orban came into power. And that's actually an analog here, right? Precedent before this court is now disfavored. And then they began to replace judges. So there is a paradigm here which we have so far resisted, but who knows where it would go. What do we do now? Even with the notion that we should be filing lawsuits and doing strategic litigation cannot be done in the federal courts because of the Supreme Court. Or at least it has to be very carefully done because of the Supreme Court. State constitutional law is, however, an extraordinary vehicle for protecting rights. When I was a litigator, we litigated before the Massachusetts Supreme Judicial Court. We got the right to choose abortion. That is enshrined in the Massachusetts Constitution, would dissolve if there's a national abortion ban, but nevertheless protected rights, eliminated the death penalty in Massachusetts, a whole host of decisions under the state constitution. The ACLU now has a special project on state constitutional law. So state constitutions as a protector of rights is terribly important, as are state AGs. I also do not dismiss, even if litigation could wind up before the Supreme Court and be a horror show, I don't dismiss bringing cases, right? I was, even just between you and me, even before I was a civil rights lawyer and before I was a criminal defense lawyer, I was a radical. And I remember bringing cases, I remember we would organize around cases in court. We talked about the expressive function of litigation, the importance of telling stories in court, because journalists report court stories. So even if you thought you didn't have a prayer of winning, but you had a good faith basis for going into court, but who knew what the judge was going to do, you nevertheless wanted to be able to bring these cases. And I think that's what we will have to do. I'm reminded of a case when I was a young lawyer. We represented 1,400 demonstrators at the Seabrook nuclear power plant. And we had a, good faith basis for bringing the case. We wound up moving for a preliminary injunction. They were all detained. And over the 5 days of the hearing, the drumbeat in the press was clear that the state of New Hampshire was spending a ridiculous amount of money detaining these young people, and ultimately within 5 days they were out. So there is an expressive function about litigation, and Americans in particular generally translate everything we do through litigation. And then in addition, even losing cases are, can nevertheless do something. When I was on the bench, I used to have what I called as an oi footnote. And it would be, the First Circuit requires that I do X, and so I'll do X. Footnote, oi, is this ridiculous? And it was essentially dissenting to my own decision. Well, Carlton Reeves in Mississippi has done me one better. And now I don't usually miss being on the bench, except when I read this decision, I certainly did. He had a gun case, criminal case involving a gun, which under the Supreme Court's Bruin decision should suggest that the case ought to be dismissed, right? Because you have a right to carry a gun. And he wrote a decision which was essentially mocking the Supreme Court's decision in Bruin. And let me give you just a quote from it, because I love it. This court, he said, is not a trained historian. The justices of the Supreme Court, as distinguished as they may be, are not trained historians. We are not experts in what white, wealthy, and male property owners thought about firearms regulation in 1791, yet we are now expected to play historian in the names of constitutional adjudication. By the time you finished this decision, you knew how ridiculous the Supreme Court's decision was, and you knew it from someone who had to apply it. So the bench can dissent to what they are having to do, even as they are doing it. And then it seems to me there could be litigation from one end of the country, particularly we talked about Schedule F, if there are wholesale dismissals of federal employees, we represent every single one. We develop defense funds for every single one. We go into court and we mobilize, and we say in court what has been done and describe what the challenges are and hope that the press follows it. We coordinate with other actors, with other groups, with other community groups, other political groups when we go into court. It's not just me and my client, it's everyone. I'm actually channeling the me that I was before 1994, which is like amazing. So yes, I believe the courts, and then there's always the cases like the Muslim ban case, where the courts did step up to the plate. Whether they will do that now, I have no doubt there will be judges who will do that in certain parts of the country. What the Supreme Court would ultimately do with those cases, who knows? But they should be brought. Americans are litigious. We use the courts to tell stories. We should tell stories now in whatever way we can. It seems to me the worst thing to do under these circumstances is to remain silent. One of the advantages of no longer being a judge is that I won't be. My husband says, there's never been a microphone that I didn't like, and he's right. Thank you.
I have many more questions up here, but we want to give the folks in the audience a chance to ask questions. And also, we want to hear from you all and your suggestions for how we all are prepared to go on the offense. Why don't we start right here, sir, if you'd like to stand up.
Yes.
Here we have a microphone coming your way.
You talked about the respect for institutions, right? There's also within the functionality of our government this respect for institutionalism, and the way that undercuts the ability to go up against the worst impulses of the right. For instance, with the most recent Supreme Court decision, I mean, I think they just gave Joe Biden permission to round up Donald Trump and Steve Bannon and everybody else, including the 6 conservative justices, put them on a plane, send them to Gitmo, and then let Kamala deny all culpability, and then let them out.
Let me write this down.
So I would just like to just to hear what your thoughts are on that subject, on that sort of difficult subject, because a lot of times people, the legislators on the left, responsible government people on the left, kind of are fighting an asymmetrical war. The other side is willing to throw everything possible, stuff that's legal, stuff that's not legal, stuff that they just dreamt up the night before, and we're like, oh no, we have to respect our institutions and we have to do things the right way. And how are we going to get ourselves out of that?
Well, let me spend 2 seconds on that. I mean, that is a dilemma. I actually want to go back and look at how it came to pass that a year ago there were numbers of cases against Donald Trump, which were very substantial cases, and now they've all disappeared. How did that happen? And part of it is, you're right, that liberal, moderate judges gave him more due process than anyone has ever had. And that's part of this approach that you're describing. On the other hand, there was also the Supreme Court, which made a huge difference. But this is, as I said, I don't have an easy answer, because taking advantage of the law is one thing, but not respecting the institutions that we serve is really another, and has long-term damage. So I think that that's actually a calculation that we have to make. I feel that way in a little bit. For example, I write a lot about judges. I mean, I criticize judges. I have criticized Judge Cannon over and over again. And I think to myself, am I contributing to the Trump chorus of delegitimizing the bench? How do I craft a line here that this judge did something wrong in this case, as opposed to this judge is a Trump acolyte? What's the legitimate even though she is, what's the legitimate criticism, and what is delegitimizing it? And it's exactly the dilemma you described, but it is a dilemma, and we have to recognize that.
Just so that no one is confused who watches this, I have to say I'm not supporting state-sponsored kidnapping of Supreme Court as a chief law enforcement officer. Look, let me, I don't have immunity. The
night is young.
Yeah, respectfully, I don't think it's a contradiction. I don't. And I think, we can't be a light version of them. Like, that's just not who we are. That's not what we stand for. If we're going to say we don't stand for breakdown of our democracy, then we have to stand for democratic norms. We have to stand for democratic institutions. And sometimes does that feel like we're fighting an unfair fight? Like they're playing with 30 men on the field? Yeah. But that's why the work that we're doing here is so important. And that goes to what I was saying earlier. We have to be consistent. We have to have credibility. In order to be consistent, in order to be credible, you have to be consistent. So we can't just care about institutions sometimes. And look, I will be very candid. I see in New Jersey people on our side of the issues attacking my office and other offices like it for doing the same types of things that they want to see us do to Donald Trump. It's not okay when he does it, and it's not okay when people on our side do it. And for us to win this long-term struggle for our democracy, we need to show the American public that we stand for something that is different. And to be perfectly candid, this long-term trend that we've seen in the demise of democratic norms in this country started before 2016. And that's why when I said about Project 2025 is going to survive well after November, regardless of who wins. And so I don't have an easy answer for you about how we do it. It's not easy. There's no silver bullet. If there was a panacea, I assure you people smarter and more powerful than me would have done it by now. It requires consistent effort and sustained effort, voting, organizing, litigating, pushing new policies, passing change at state and local levels. All of it is important, but it's hard work, and we can't be inconsistent in that effort.
Yeah, okay. We have time for one more question. I'm gonna let you choose, wherever you wanna take the mic.
Eeny, meeny,
Someone had
miny,
got
mo
my
works.
attention earlier, but I don't think they're raising their hand. I can bring you the mic. I can hold it for you.
There was a case, I guess it was a gerrymandering case in the South, maybe Mississippi or something. And the governor, I think it was the governor, the Supreme Court didn't go their way on the boundaries of the gerrymandering case. And then it was, maybe the governor or some other official said, well, we're going to, something to the effect that, well, regardless of what the Supreme Court said, we're going to go ahead and, we're still going to fight it because this is what we want to do. I can't remember. I think it was a Mississippi case. And I wondered what happens with the Supreme Court situation the way it is. Do you think that just even the little lines they draw anymore, what if this sort of authoritarian worldview that some of the states have, like they're their own little bastion of law and order, what happens if they even defy the Supreme Court? Is there any recourse? Is there any result of that?
I appreciate your question very much, and if I may add to it, a friendly amendment to it, because I was thinking, as you all were talking about the beauty of state constitutional claims and about brave progressive attorneys general, I just thought, we have people watching from all over the country, and some of us live in Mississippi and Georgia and Texas and Florida. So as we're offering hope, I'm feeling hopeful. We would love your reflections on what do we do in these other states, right, where we don't have wonderful state constitutions, where we don't have attorneys general who are as committed, General Platkin, as you are to protecting civil rights.
And don't say move.
And we are committed to our states. And how do we support, besides voting, the leaders who are bringing the kind of change we want to see? So if you can combine all of that and your closing remarks.
yeah,
then that would
2
be great.
minutes.
I'll be very brief on this. I'm the Attorney General for New Jersey, so my job is to keep, first and foremost, 9.3 million people safe. But as part of our effort, I think as a coalition, we have worked hard to provide meaningful change and relief and safety for 330 million Americans. When we come together as coalitions of attorneys general, we often are fighting for people who don't live in our states. Thanks to efforts by our offices and advocacy organizations, Mifpristone is still available across this country, regardless of what the dozens of Republican attorney generals try to do. On gun laws, we are constantly in court working to protect them and keep our strong gun safety laws in place, despite what the Supreme Court has done. And by the way, you mentioned Mississippi, and we didn't get to what Project 2025 says about crime reduction, but I would just note that New Jersey, you're 6 times less likely to be shot and killed than Mississippi, and that's a policy choice that leaders in Mississippi made. It's not because they're more violent there that they made, and the folks in Mississippi should wonder why the pro-law and order, people that they're hearing from are allowing their kids to be killed at record levels relative to where they are in states that have taken strong and common sense steps. In 2018, New Jersey stepped in and defended DACA when the Department of Justice under President Trump refused to do so and kept DACA as a lawful program for years before the Biden administration started defending it again. The litigators who did that, by the way, are in this room, literally. So as on behalf of the AGs, Keith and I, and the others in our coalition, I obviously care about New Jerseyans, but I care about Americans, and we will continue to fight and stand up and file briefs and be in court and file lawsuits on behalf of the people of this country when they're at risk.
think the states that don't have a constitution or a state court system that enables you to protect rights should still oppose even if these are lawsuits that are not going to win, but lawsuits that will challenge the status quo, challenge what is happening to you. That's what I was talking about the expressive function of the law. When you go into court, the press covers it. And the stories, for example, of the women who are struggling to get abortions are stories that press is covering, but certainly covering it more when you wind up litigating it. So whatever the outcome is, I also do not want to cede the courts to Project 2025. And so we should continue to plumb that no matter what. Let me say one other thing about Project 2025, which is both a good thing and a bad thing. The bad thing is that they've said the quiet part out loud and that they've put this in writing, and that enables us to challenge it. It also enables it to live beyond this administration. In other words, it being in writing and gives us a target and lets us know what they've planned. But on the other hand, it becomes a document that will live on, and that's very troubling. But I think you have to fight in whatever way you can, and I'm not going to give up on the courts.
Thank you. Danya,
Yeah,
final words.
the last time around, I think a lot of people were surprised that Trump won the election. And a lot of people, I'll include myself, were caught kind of flat-footed. This time, you said it's a blessing and a curse, but no one's going to be caught flat-footed. Everyone is ahead of the curve on this one. They've given us their manifesto. They've told us exactly what their plan is. And we're just gonna meet it, exactly where they live. We're gonna be there on defense and on offense. And so that is actually a positive note, I think, to end on, because we see their game and we're gonna up their game. And I think that's something we can all, I don't wanna say look forward to, but plan on.
Please join me in thanking our wonderful panel.
I love that loud applause. I love the energy. We're going to make it as hot for autocracy as it is hot in this room right now. Thank you, Allegra. Thanks to our wonderful panelists. We are going to circulate those principles for comment, those 10 principles for your input and ideas, also with all of our panelists and chairs. And what a great day. It's so exceeded expectations. Thanks, everyone. Thanks for joining us.